Generally speaking, there are no magic words when it comes to what you have to use to describe your trademark. So you don't have to say clothing specifically, whatever item. You just want to be as broad as you possibly can without being overbroad to get a refusal. Alternatively, you don't want to go really narrow because inherently you're limiting yourself perhaps more than you need to. So let's use shirts as an example. If you say, I claim clothing, namely shirts, perhaps shirts encompasses t-shirts, maybe it's tank tops, maybe crop tops, whatever other subspecies of shirts would be under that shirts umbrella. But if you just said clothing, the USPTO will say that's ambiguous. It's too vague for us to give you trademark rights. We need more detail. So there's a little bit of a sweet spot. You have to be broad enough to encompass all of your intended uses, but you also want to be, we want to avoid a situation where you're overbroad and you set yourself up for an office action. As far as choosing the actual class of goods or services that applies to your mark, there are some USPTO resources on that. There's a trademark master ID list where you can go in and you can search and see what other people have registered for their mark and see the way they've used language, and perhaps it matches yours, and therefore you would fall in probably the same class. But again, the best answer is to speak to an attorney. They will be able to tell you whether or not you're selling software, and therefore it's in class 9, or if you're actually selling software as a service, and therefore it's in class 42. It really is a legal question. It's one that you can perhaps come to a conclusion yourself, but check with a professional before you decide to submit an application.
Protect your brand with Trademarkia. Register your trademark on trademarkia.com.